Thank you very much, Mr. Chair. Welcome, Judge, and good morning.
Good morning,
Good to
Senator.
see you again. Since we're on Roe, I wasn't going to begin with this, but I well recall the time we spent in my office, and we talked about precedent, and in my opening remarks, I indicated that if anything had super precedent, Roe did in terms of the numbers, and I've put that in the record. Here's why it becomes of concern. The president said that he would appoint someone who would overturn Roe. You pointed out to me that you viewed precedent in a serious way in that it added stability to the law. Could you elaborate on the point that you made in my office on that?
I'd be delighted to, Senator. Part of the value of precedent, it has lots of value. It has value in and of itself because it's our history. And our history has value intrinsically. But it also has an instrumental value in this sense. It adds to the determinacy of law. We have lots of tools that allow us to narrow the realm of admissible dispute between parties so that people can anticipate and organize their affairs. It's part of the reason why the rule of law in this country works so well. We have statutes, we have rules, we have a fact-finding process and a judicial system that's the envy of the world. And precedent is a key part of that because, as the chairman pointed out when he quoted a piece of mine, once a case is settled, that adds to the determinacy of the law. What was once a hotly contested issue is no longer a hotly contested issue. We move forward. And Senator, the value of that is the United States Supreme Court takes something like 70 or 80 cases a year. That is a tiny fraction of all the disputes in our federal legal system, right?
Right.
My law clerks tell me it's something like 0.001%. And they're unanimous in those cases which have divided circuit judges. That's why the Supreme Court largely takes the case, because it's divided us. It's one of the rare cases where we disagree. They're unanimous 40% of the time.
One other question.
Sure.
Do you view Roe as having super precedent?
Well, Senator, a super precedent is
in numbers, 44.
It has been reaffirmed many times. I can say that. Yes. Yes,
dozens.
Yeah.
All right. I would like now to take you back to 2005 when you were in the Justice Department, and I want to explain to you why I'm going here. This has to do with torture. The Intelligence Committee was informed in 2006, and Attorney General Gonzalez played a role in this, of the nature of the enhanced interrogation techniques, and we were given a very soft view. Senator Rockefeller became chairman of the committee in 2007 and began a study of 3 detainees and the enhanced interrogation techniques. When I became chairman in 2009, I added that, and we took all of the major detainees and looked at them in a 6-year study. The staff spent long hours analyzing every cable, every email, looking at more than 100 interviews, and essentially putting in a 7,000-page report, 32,000 footnotes, documenting where the information, there are no conclusions, they're just facts. That 7,000-page report has remained classified. I have read it. We have put out a 450-page summary, which is public. And in that summary, we indicate that those cases that the administration spelled out where torture produced operable intelligence was simply not so. We elaborate on that big report, and my hope is that one day, not too distant, that report will be declassified so the American people can actually see. But I wanted to ask you some questions along these lines. It's my understanding that the set of talking points were prepared for a press conference for the Attorney General on November 22, 2005. The talking points ask whether, and I quote, aggressive interrogation techniques employed by the administration yielded any valuable information, end quote. And in the margin next to this question, you handwrote one word, yes. What information did you have that the Bush administration's aggressive interrogation techniques were effective?
Senator, I'd have to see the document. I don't recall.
All right,
I've been sitting here. It's been a long.
Why don't we do this?
Time.
I'd be happy to share the documents with you. I took these pages out of my binder. I think they were there, so I wouldn't have to pause. But let me just hold up that answer.
Sure.
And we'll get you the documents on that. Because let me do the next question. In December 2005, after the passage of the Detainee Treatment Act, you advocated that President Bush should issue a signing statement to accompany the law. In an email you sent to Stephen Bradbury and others, you said the signing statement would, and I quote, this is your quote, help inoculate against the potential of having the administration criticized sometime in the future for not making sufficient changes in interrogation policy in light of the McCain portion of the amendment. This statement clearly and in a formal way would be hard to dispute later, puts down a marker to the effect that McCain is best read as essentially codifying existing interrogation policies, end quote. To be clear, the context was that earlier in 2005, the Justice Department's Office of Legal Counsel had concluded that CIA interrogation tactics like waterboarding and sleep derivation did not amount to cruel, inhuman, or degrading treatment. I read your email as advocating a continuation of these interrogation techniques, and worse, saying that Senator McCain's amendment actually codified them, which it did not. Is that true? And doesn't it mean that when you wrote this email, you were condoning waterboarding as lawful?
Senator, I'd want to see the email again. I don't feel comfortable commenting on documents that aren't in front of me, but I can say this, that I do remember.
My staff has the documents
Great.
here. They can bring them down
That'd
to
be
you
great.
right now.
Thank you. That'd be
Okay.
wonderful.
And then I'll put aside this part.
Okay.
You'll have the documents because there
All
are
right.
more, and I'll go on to the next subject.
No, that's fine. I'm happy.
Is that all right? I know documents.
I'd like to just know what I'm talking about. My recollection generally, I can, from 12 years ago.
Eric, bring him the
Sure,
documents, please.
Yeah. Thank you, Eric. My recollection generally, working on the Detainee Treatment Act, Senator, was that at that time, after Razul was issued by the Supreme Court, there were a lot of habeas petitions coming in from detainees at Guantanamo Bay, some brought by my friend Neil Katyal. And there was an effort by some in the administration, along with many on Capitol Hill, to try and provide a regime for the processing of those claims in a way that would conform with the Youngstown ideal of Congress and the President acting together in unison. And that Senator McCain and Senator Graham put together legislation that emphasized that not only was torture unacceptable, which it always had been under U.S. law, but the cruel, inhuman, and degrading treatment was also unacceptable
But let
under
me help
U.S.
you
law.
here. I know from the documents that you worked on the Graham effort.
Yes.
For example, a self-assessment that you wrote said that you, quote, helped coordinate the legislative effort on the Graham Amendment within DOJ and in consultation with DOD and others.
That's absolutely right, Senator. I sure did, and I'm proud of it because we managed to come up with a bipartisan bill that I think passed this body with over 80 or maybe 90 votes, I don't remember, which did two things. One, affirmed this country's commitment to prevent cruel, inhuman, and degrading treatment. And second, which provided a regime that was agreed by the Congress and the President on how Guantanamo detainees should have their claims processed.
Except, after you read the documents, just so you know, the conclusion that we come away with is that when the bill on the McCain amendment was about to be voted on, you forwarded press articles explaining what having these two provisions together meant. That was the McCain amendment prohibiting torture and confining it to the Army Field Manual.
Yes.
And the Graham amendment, which would bar habeas. In other words, a detainee could not use the habeas corpus right to file in a court of law and challenge their conditions of detention. So that was looked at as offsetting McCain, but basically preventing habeas corpus from being used, and of course it was overturned by the court.
Senator, you're absolutely right that it was eventually litigated, as all these things are. There was a bipartisan effort, and it was between the Department of Defense. The Department of Defense wanted congressional approval for something so that they knew what the rules would be. They were desperate to have some congressional involvement and investment in this process. And as a lawyer, that's all I was. I was a lawyer for a client, right? I was advising them on how to go about doing that legally in conjunction with Senator Graham's office and others. And it was a bipartisan effort, and we put together our best effort. The D.C. Circuit upheld it. The Supreme Court of the United States, eventually many, many years later, found that the process was insufficient. And that's the Boumediene case, as you know, Senator. But to say that there was no process would be inaccurate, too, because the Detainee Treatment Act had a long list of prescribed processes, and the question just simply was whether they were adequate enough under the suspension clause. And that was a close case that divided the court very closely. And I respect that decision as a precedent of the United States Supreme Court no less than any other, Senator.
One last question on this. When President Bush signed the Detainee Treatment Act, he issued a statement that basically said he would only construe the law consistent with his powers as Commander-in-Chief. According to press reports, administration officials confirmed, and I quote, "The President intended to reserve the right to use harsher methods in special situations involving national security," end quote. In other words, the signing statement reflected the President's belief that he had the power to not comply with the law he had just signed. According to emails, and this you'll verify, you were involved in preparing that signing statement, and you advocated for the issuance of the signing statement. They even showed you saying to the top State Department lawyer that Harriet Miers, the White House counsel, quote, "needs to hear from us. Otherwise, this may wind up going the wrong way."
Well, Senator, I can tell you what I recall. I haven't read.
Okay.
I need to read the email,
That's
but my loose recollection of something that happened, I think, 11, 12 years ago, is that there were individuals in maybe the Vice President's office who wanted a more aggressive signing statement along the lines that you've described, and that there were others, including at the State Department, who wanted a gentler signing statement. And my recollection sitting here, as best I can give it to you without studying the email, is that I was in the latter camp. John Bellinger, among others, I would have associated myself with there. And I don't know what was in the President's head when he wrote the signing statement. I can't tell you that. I don't know. I can only tell you what I remember, and I certainly would never have counseled anyone that they could disobey the law.
Okay, I have no reason not to believe you, but if you will read those.
Sure.
And then in my second round, we'll go back to
Sure.
it. And I'd be very happy to, because I think you'll see that we didn't make this up.
Well, Senator, I'm not
okay.
suggesting you are, but there was a tug of war among parties in the
I'm
White
sure
House.
that.
Right. And
I wanted to know which side you were on.
well, count me in with John Bellinger most of the time on these things, okay?
Okay.
All right? And
Okay.
that's my recollection. And Matt Waxman would be another one. And so that's my recollection, Senator, sitting here, and I'll study these.
Okay. Let me ask you a question on wiretapping. In December of 2005, news broke that President Bush had ordered the NSA to intercept the content of certain communications of Americans without a court order, outside of the requirements of the Foreign Intelligence Surveillance Act known as FISA. You helped prepare the public defense of the program. For example, in draft testimony that you prepared for Attorney General Gonzalez defending the program, you wrote this, quote, "These authorities are vested in the President, and they are inherent in the office. They cannot be diminished or legislated away by other co-equal branches of government." Paul Clement, President Bush's Solicitor General, quote, found this proposition from the testimony. Do you still believe that the President has inherent authority, this is important, to intercept the communications of Americans in the United States that cannot be legislated away by Congress?
Goodness knows, Senator.
Good.
And I didn't believe it at the time. What I was serving at the time, as I recall, again, my recollection, and I'd be happy to review whatever you have before you, is that I was acting in the capacity as a speechwriter and taking material produced by the components that were responsible for litigating these issues, including Mr. Clement, Paul Clement, dear friend of mine, and the Office of Legal Counsel and others, and assembling it to put words in together that sounded like English. You know, and I think people like my writing, and that was my job. I think I was the scribe.
Okay, let's move on. I'd like to go to the Heller case. When we met in my office, we discussed the Heller decision, which you said you were open to discussing since the case had been decided. At that time, you said you thought both the majority opinion written by Justice Scalia and the dissent written by Justice Stevens were brilliant examples of originalism, where both justices sought to explain the reasoning by looking at the original public meaning of the Second Amendment. Which decision did you agree with and why?
Well, Senator, I think we've alluded to my difficulty here. I do think everything you've just said is accurate. Both Justice Scalia and Justice Stevens wrote excellent opinions in that case. I am not here, though, to grade my boss's work. That would be kind of impertinent of me, I suspect. And certainly I'm sure they would think so. I also worry that saying I agree with one or the other indicate to clients or to litigants in future cases, because it's now a precedent of the United States Supreme Court. It's binding. It's the law, whether we like it
Right.
or not. It's the law. And if I start saying I like one opinion or I like the other opinion,
All right.
I'm signaling.
I'll let you off the hook.
Oh,
Let me go to another one.
thank you, Senator.
In D.C. v. Heller, the majority opinion written by Justice Scalia recognized that, and I'm quoting, "Of course the Second Amendment was not unlimited," end quote. Justice Scalia wrote, for example, laws restricting access to guns by the mentally ill or laws forbidding gun possession in schools were consistent with the limited nature of the Second Amendment. Justice Scalia also wrote that, quote, "Weapons that are most useful in military service, M16 rifles and the like, may be banned," end quote, without infringing on the Second Amendment. Do you agree with that statement, that under the Second Amendment, weapons that are most useful in military service, M16 rifles, and the like may be banned?
Senator Heller makes clear the standard that we judges are supposed to apply. The question is whether it's a gun in common use for self-defense, and that may be subject to reasonable regulation. That's the test, as I understand it. There's lots of ongoing litigation about which weapons qualify under those standards, and I can't prejudge that litigation.
No, I'm just asking you, do you agree with his statement? Yes or no?
Are the statements out of the Heller decision from the United States?
Justice Scalia's statement.
Well, whatever's in Heller is the law, and I follow the law. Well, it's not a matter of agreeing or disagreeing, Senator, respectfully. It's a matter of it being the law. And my job is to apply and enforce the law.
All right, fair enough. Let me give you another one. The Fourth Circuit. Judge Harvey Wilkinson authored a separate concurrence in the Fourth Circuit case, Colby v. Hogan. Here's what he said. No one really knows what the right answer is with respect to regulation of firearms. I am unable to draw from the profound ambiguities of the Second Amendment an invitation to courts to preempt this most volatile of political subjects and arrogate to themselves decisions that have been historically assigned to other, more democratic actors. Disenfranchising the American people on this life and death subject would be the gravest and most serious of steps. It is their community, not ours. It is their safety, not ours. It is their lives, not ours. Do you agree with Judge Wilkinson that the Second Amendment is ambiguous? If so, should the ambiguity be decided by the courts or by legislatures?
I'd begin by saying I hold Judge Wilkinson in high regard. He's a very fine man and a very fine judge.
Can you do yes or no?
No, I wish I could.
I wish you could, too.
But, you know, the Supreme Court of the United States isn't final because it's infallible, as Justice Jackson reminds us. It's infallible because it's final. And Judge Wilkinson had his view, and the Supreme Court has spoken. And Heller is the law of the land. And Judge Wilkinson may disagree with it, and I understand that. And he will follow the law no less than any other judge in America. I am confident of that. He's a very fine judge who takes his oath seriously.
Okay. I asked you that question on super precedent, and let me end with one on workers' rights, if I might. As you know, there have been a number of Supreme Court cases where the court has made it harder for workers to hold their employers accountable when they have experienced discrimination or be injured on the job. And we've discussed that one case, Trans Am, I think 3 or 4 of us. Let me give you a short list. Ledbetter versus Goodyear Tire, which limited the ability of women to seek equal pay. Gross v. FBL Financial Services, 2009, which made it more difficult to prove age discrimination. And the University of Southwest Texas Medical Center v. Nassar in 2013, which made it more difficult for employees to prove they've been retaliated against for reporting discrimination, including based on race, gender, national origin, religion, and other factors. Vance B. Ball, which made it more difficult for workers to prove just plain discrimination claims. As Senator Whitehouse pointed out, each of these cases was 5-4, and Justice Scalia voted with the majority against the employee in every case. President Trump and others have said, you are the next Scalia. So I think it's only fair to ask you, do you disagree with any of the majority opinions in these cases? If so, which ones do you especially disagree with and why? These have already been decided.
I understand, but again, if I indicate my agreement or disagreement with a past precedent of the United States Supreme Court, I'm doing two things that worry me sitting here. The first thing I'm doing is I'm signaling to future litigants that I can't be a fair judge in their case because those issues keep coming up. All of these issues, as you point out, keep coming up. Issues around all of these precedents will continue to be litigated and are hotly litigated. I've had post-Ledbetter Act cases in my court, for example.
Then how do we have confidence in you that you won't just be for the big corporations, that you will be for the little men? This is the question that Senator Hirono, I think, so well asked yesterday. You know, those of us, I think on both sides, care very much about workers' rights. But the record is such that one questions whether the court is capable in its present composition to give a worker a fair shot. So I'm just looking for something that would indicate that you would give a worker a fair shot. Maybe it's in your background somewhere that I don't know about, but I'd like to have you respond to it any way you can.
Senator, I really appreciate that. And I think there is a way you can take a look at this question without me potentially prejudging a case. And I appreciate your respect for that. And just to finish that thought, I'm concerned that I have to look the litigant in the eye in the next case. And if I've prejudged that case, they can look at me and say, you're not a fair judge. And I've got no answer for that. I've got no answer for that. So what I think can give you comfort in this area is, Senator, I know a case or two has been mentioned yesterday. Respectfully, I'd suggest that does not represent the body of I've written 2,700, I participated in 2,700 opinions over 10 and a half years. And if you want cases where I've ruled for the little guy as well as the big guy, there are plenty of them, Senator. The Ute Indian tribe.
Would you be willing to submit some of them?
Oh,
it's
goodness.
hard to read 2,700 cases.
I'll name a bunch of them right now.
I mean, Trans Am.
I'm sorry, Senator. Of course, Ute 5 and 6, Fletcher, the Rocky Flats case, which vindicated the rights of people who had been subject to pollution by large companies in Colorado, uranium pollution. I point you to the magnesium case, similar pollution case in the Salt Lake City area. Colorado's effort with renewable energy upheld that. Or versus City of Albuquerque, involving pregnancy discrimination in the police department in Albuquerque. WD Sports, a discrimination claim. Casey, Energy West, Crane. Simpson versus CU, involving young women who had been harassed by the football team. AM versus AM, Browder, Sutton. I can give you a long list.
Helpful. And we'll find them and we'll read them.
And Senator, the bottom line, I think, is that I'd like to convey to you from the bottom of my heart is that I'm a fair judge. And I think if you ask people in the 10th Circuit, is he a fair judge, you're going to get the answer that you got yesterday from both Senator Bennett and Senator Gardner and from General Cotchiel, and the same answer you got from Senator Allard and Senator Salazar 10 years ago. And Senator, I can't guarantee you more than that, but I can promise you absolutely nothing less.
Okay, I have a minute and 21 seconds. Let's talk Chevron. That's been used, you know, thousands of times, and it really perplexes me. Olympia Snow and I did something that took me 12, 13 years to get to, and that is changing the corporate fuel economy standards. And thanks to Senator Inouye and Senator Stevens, they put it finally in a commerce bill, and it passed. So now we are on our way to 54 miles a gallon. Here's the point. We could do the rules for the first 10 years, but who knew we needed the experts to do them from that point on. So what we said in the legislation was that science would prevail. And that's still the law. It's working. the goal is, I've read articles, they say there'll be 54 miles by 2025 if this continues. What is wrong with that? How else could we have done it?
I'm not aware of anything wrong with that, Senator. I've never suggested otherwise.
But what you said is the Congress could not legislate by leaving some of the rules up to the scientists or other professionals in departments, as I understood it, in Chevron.
I appreciate the opportunity to correct this misunderstanding,
Sure,
Senator.
appreciate it.
The case I think you're referring to is Gutierrez.
That's correct.
It involved an undocumented immigrant to this country. Okay. And the question was, there were two conflicting statutes. One said he could apply for immediate discretionary relief in this country from the Attorney General. Second said he had to wait outside the country for 10 years. We had a judicial precedent that said the first statute controls. That was the ruling of our court. After that, 3 or 4 years, I can't remember exactly, the Board of Immigration Appeals, in its infinite wisdom, says our interpretation is wrong. Chevron. You have to undo your precedent, the judicial precedent that this man had relied upon, and that he now had to wait outside the country not just 10 years, but 13 or 14, because it took them so long to make up their mind. Well, Senator, that reminded me of, you know, when Charlie Brown's going in to kick the ball, and Lucy picks it up at the last second. And that struck me as raising serious due process concerns, fair notice, and separation of powers concerns, when an executive bureaucracy can overturn a judicial precedent without an act of Congress. That's what the case was about. And it suggested, respectfully, Senator, that under the APA, the Administrative Procedures Act, this body tasked judges to decide legal questions and left to administrative agencies great deference when it comes to fact-finding. Okay? That's how I read Section 706, is fact-finding by scientists, biologists, chemists. The experts get great deference from the courts. The only question is who decides what the law is? And can a man like Mr. Gutierrez, the least amongst us, be able to rely on judicial precedent on the books, or can he have the ball picked up as he's going in for the kick?
I think I've exceeded my time.
Well,